Why do we need amendment in our constitution? So that's a question that we need to address in this particular session. Hello everyone, welcome to Indian Polity Mastery. In this video, we are going to discuss about that question. Why do we need amendment? As we all know that our constitution was actually came into existence in the year 1950. Okay, January 26th. That is known as the commencement of the constitution. But after the commencement, Dr. B.R. Ambedkar once said, within this limited time frame, what we had made or what we could do was a workable constitution. So it is the duty of the upcoming generation to make it as a perfect one. So how can they make it as a perfect one? Then they need to have that option to make change. That particular option to make change in our constitution is amendment. Article 368 in part 20 of the constitution deals with the powers of the parliament to amend the constitution and its procedure. So it is not like we are making a change to the constitution. They need to follow certain procedure while amending the constitution. That is also covered in this particular section, in this particular article. The parliament may amend the constitution by way of addition, variation or repeal any provision in accordance with the procedure laid down for the purpose. So there is a procedure that we need to follow while we are actually amending our constitution. But what do you mean by this amendment? By this amendment, it means it's a change that we are actually making. That change can be either we are adding certain things or we are deleting certain things or we are changing, editing certain things. Okay, so that is what the amendment means. The parliament cannot amend the provisions which form the basic structure of the constitution, which means the parliament has the authority to amend the constitution, but judiciary or the Supreme Court is the guardian of our constitution. So the Supreme Court ensures that everything is going on in accordance with the constitution and its rules. So when we are making a change to our constitution, it should not affect the essence or it should not affect the crux of the constitution or it should not affect the objective of the constitution. That is why the Supreme Court has come up with a provision called as the basic structure doctrine. Okay, in that basic structure doctrine, the Supreme Court has added certain important provisions which are enshrined in our constitution, like the rule of law is there, the fundamental rights are there. So certain provisions are actually added into this basic structure. So whenever the parliament is making certain amendments to our constitution, it should not affect this basic structure. It should not change the basic structure. So that is why this Keshavananda Bharati case in the year 1973 is one of the prominent cases in relation to the Indian Constitution and its provisions. So from where we have adopted this particular provision of amendment, we have adopted the provision of amendment from the South African Constitution. As we all know, we have drawn many provisions from different parts of the world. Or from different countries and from different constitution we have adopted the provisions into our constitution. Like the fundamental rights are adopted from the American Constitution, the fundamental duties we have adopted from the USSR, the amendment procedure we have adopted from the South African Constitution, the DPSP, Directive Principles of State Policy, we have adopted from the Irish Constitution. So like that we have adopted many things. Same like that we have adopted the amendment procedure from the South African Constitution. The Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but make sure that it is not affecting the basic structure of the Constitution. So without changing the basic structure, without affecting the basic structure, the Parliament can make changes to our Constitution. So Article 368 of the Constitution provides for two types of amendments. Okay, two important types of amendments are actually given by Article 368 of the Constitution. And what are those two types? One, amendment by a special majority of the Parliament. Another one, amendment by a special majority of the Parliament with the ratification of half of the total states. So these are the two important types of amendments which are actually enshrined in Article 368 of the Constitution. But there is another way of amendment also, that is by simple majority of the Parliament, but they have not included that in the Article 368. The simple majority is a majority of the members of each house present and voting, similar to the ordinary legislative process. But the thing is, it is outside the scope of Article 368 of the Constitution. So what is special majority of the Parliament? So the special majority of the Parliament means the majority of total membership of each house and the majority of 2/3 of the members of each house present and voting. So two important criteria we need to satisfy here. One is the majority of total membership of that house, both the houses actually, and the majority of 2/3 of the members of the house present and voting. So if we are satisfying both these conditions, then we can say that a particular resolution is passed by a special majority. So the expression total membership means the total number of members comprising the house, irrespective of the fact whether there are vacancies or absentees. That means the entire number of people in a particular house. That is the total membership of the house. So what are the important provisions which we amend using the special majority of the Parliament? They are fundamental rights, directive principles of the state policy, and all other provisions which are not covered by the first and third categories. The first category is the ordinary lawmaking process, that is the simple majority. The last category is the special majority of the Parliament with the ratification of half of the states. Now we are going to understand that. By special majority of the Parliament with the ratification of half of the states. So these provisions of the Constitution which are related to the federal structure of the polity can be amended by special majority of the Parliament and also with the consent of half of the state legislature by simple majority. Very, very important, because if we are actually amending something which has that character of a federal nature, okay, or a federal structure, then we need to have the special majority plus the ratification of half of the states. So in these states, how they are actually passing? In these states, they are actually passing it through a simple majority. If one or some or all the remaining states take no action on the bill, it does not matter. The moment half of the states give their consent, the formality is completed. So the provision, so what we require here is the consent of half of the states. So the moment we are getting the consent of half of the states, then the procedure is completed. There is no time limit within which the state should give their consent to the bill. Okay, now let us understand what are those federal structure, character or federal things that we need to amend using the special majority plus ratification of the states. Okay, so the following are the important provisions which we can amend using this particular amendment method. 1. The election of the president and its manner, the extent of the executive power of the union and the states, the Supreme Court and high courts, the distribution of legislative powers between the union and the states, any of the list in the 7th schedule, a representation of states in parliament, and power of parliament to amend the constitution and its procedure, that is Article 368 itself. Okay, so if you want to make certain changes to Article 368 also, you need to follow this particular amendment procedure, that is by a special majority of the parliament with the ratification of half of the total states. So these are the important aspects regarding the amendment procedure. I think now you got an answer. Why do we need amendment in our country? Okay, why do we need amendment in the constitution? I think you got the answer now. If you like the video, please share, subscribe and like the video, and please do share it with your friends if you think that this is useful for them. And I hope it is useful, and I hope it will be helpful for your examination preparation, the civil service examination preparation. Thank you.